Federal law applies to interstate transactions where a party in one state sells property to someone in another state. Coordinating these real estate transactions requires agents to follow regulations governed by the Secretary of the United States Department of Housing and Urban Development, HUD, through the Office of Interstate Land Sales Regulation. The set of rules that applies to these special arrangements is called the Interstate Land Sales Full Disclosure Act of 1968. Also known as ILS-FDA or ILSA. The act was passed by Congress as a tool to protect consumers from fraud stemming from the lease or sale of land across state lines. Anti-fraud provisions aim to protect buyers from getting stuck with property that turns out not to be as marketed. Most U.S. buyers realize there isn't any oceanfront property in Arizona, but developers and real estate investors work with buyers and sellers in every state and every country around the globe. It is impossible to intimately know every street corner and country lane in every city, state, territory, or foreign country. Before we discuss some of the main requirements under the ILS-FDA, we need to clarify a few terms in the HUD lexicon. First, interstate provisions don't just cover real estate contracts between buyers and sellers in different U.S. states. The federal regulations apply to any offer to sell real estate located within incorporated and unincorporated boundaries of municipalities, counties, states, and foreign countries where consumer transactions are not sufficiently covered under state jurisdiction. Keep these definitions in mind as you listen to this lesson on full disclosure regulations. Lot. Even though the Act's name seems to imply these regulations govern only land, that doesn't mean HUD only monitors sales transactions of unimproved acreage or tracts. HUD uses the word lot to describe any undivided interest in vacant portions of land offered for purchase, and land with structures as long as the property for sale includes exclusive use rights. For example, condos, occupancy-ready homes, units in a subdivision, and unimproved land are all lots as far as HUD regulators are concerned. Sales. HUD uses sale to describe any obligation or arrangement for consideration to buy or lease a lot. So, if you decide to read through the Act, remember that seller could also mean lessor. Subdivision. Describes a land section, whether already divided or as part of a plan to be divided in the future, for sale or lease, as part of a shared promotional plan. Now, let's look at some of the requirements for developers. Congress passed the Act in response to growing concerns over fraudulent and deceptive marketing practices in the United States. Developers were pre-selling subdivision lots or taking substantial deposits with a promise to begin development soon, and then delaying projects for many years. To prevent this consumer abuse, Congress established regulations that require subdivision registration with the appropriate government agency and mandate contract cancellation options, rescission. Developers are also required to provide certain disclosures to the government and potential buyers. Here are the main requirements. Number 1. Registration and reporting. To ensure that consumers receive all appropriate information before signing a contract, ILSA requires some subdivision developers to register complete plans with federal regulators and provide certain disclosures to prospective buyers. In 2011, changes to ISLA regulations J, K, and L mandated both subdivision developers and condominium developers with at least 100 non-exempt lots or units register development plans and provide all potential buyers with a comprehensive property report prior to contract signing. Number 2. Informing potential buyers. Developers must provide certain information to prospective buyers before signing contracts. For example, in addition to giving buyers a copy of the right to cancel contract policy, developers must inform purchasers of the risks associated with buying lots. They also must deliver names and contact information for utility providers to allow verification of services and costs available, and provide a detailed list of all liens and encumbrances on the lot or lots. Number 3. Disclosing progress via comprehensive property reports. We mentioned this report previously, but real estate agents and brokers sometimes get caught in the middle between buyers and sellers, especially if full disclosure reports aren't accurate and up to date. So we're going to list some of the most important details included in this report. This report is intended to be very detailed in order to give buyers all the information they need to make an informed purchasing decision. The report includes, but is not limited to, information on the following items related to each unit or lot. Construction of roadways, including the start date, expected completion date, percentage of project completion, road surface, and units, such as miles or sections, distance traveled over paved and unpaved roads, and the population in nearby communities. Utility services, broken down by service, such as water, gas, telephone, electric, sewer, trash removal, etc. Information includes the provider's name and contact information, along with the construction starting date, percentage of construction completed, expected date of completion, and date for services. This section also includes estimates for additional fees beyond the purchase price associated with connecting to utility service and dues for common area. Restrictions and association details include information about property owners, associations, fees, and covenants. Relevant documents pursuant to a pending sale may include zoning regulations, plats, surveys, environmental impact statements, and permits. Statements on climate and subdivision characteristics include floodplain and soil erosion data, if applicable, drainage plans, environmental hazards specific to the location, occupancy restrictions, and nuisance ordinances or known issues. Additional notices may include resale or exchange programs, special situations particular to foreign transactions, and violations and current litigation. Depending on when developers sell lots and whether homes, condos, or other residential structures are on the property, other information may be included. Also, with an address and phone number to reach federal regulators to file a complaint or confirm information in the report, Every comprehensive property report should include the developer's name, address, and other contact information, the name of the subdivision, complete local information, including county, state, and country, selling agent's name, and the number of lots and the number of acres in the subdivision. One final thought before we move away from the requirements. Although developers are required to register and submit reports, maps, and plans for subdivision development, the federal government does not certify reports to buyers as accurate or complete. There are substantial financial penalties and possible jail terms if developers or anyone knowingly makes false statements on interstate sales disclosure forms. It behooves real estate agents to advise investors and private real estate clients to verify the information and to thoroughly read the rescission options before signing a purchase contract. Now, let's move on to a discussion about exceptions and exemptions. Federal regulations provide three types of exceptions: full statutory and partial statutory exemptions for subdivision oversight, and regulatory exemptions, which permit exceptions for individual lots. Let's look briefly at a few exemptions. Fewer than 25 lots exception. Small subdivisions with fewer than 25 lots are generally eligible for full statutory exemption. However, even subdivisions with more than 25 lots may be able to qualify if fewer than 25 lots are offered for sale because some lots, such as designated green spaces and parks, are offered for sale or lease under the Common Promotional Plan. Improved lots, land with a ready-for-occupancy residential structure, are eligible for full exemption status, providing construction can be completed within 24 months after the sales contract is executed. In this case, ready for occupancy means utilities are connected and the residence is fully habitable. Being obligated to complete one residential improvement does not obligate a developer to complete all buildings within a subdivision. Developers may opt to implement a staged development plan that allows full development to extend many years. Business-to-business transactions. Sales to builders who purchase lots specifically for the purpose of building residential structures or for resale to a person or persons who plan to build residential housing are exempt from federal regulations. However, selling or leasing land to an individual who plans to build his own home is not eligible for exemption status under this section of ISLA. Zoned, restricted real estate transactions. Industrial and commercially zoned land is exempt from the Act, provided that certain conditions are met. Local authorities must approve access via a public roadway to at least one edge of the legal boundary of the subdivision. In addition to the access, the purchaser or lessee must be a legally organized business entity before recording the deed or executing a lease. Finally, the purchaser must attest in writing that the property will be used solely for commercial or industrial activities of the entity, or provide evidence that there is a legal binding agreement in place to sell or lease to a business engaged in commercial business activities. The Interstate Land Sales Full Disclosure Act is complex and changes from time to time to ensure consumers have protection against fraud and abuse when dealing with out-of-state developers and land investors. Sometimes, other federal agency rules and guidelines overlap or directly and indirectly impact ISLA. You may see regulations from the Consumer Finance Protection Agency drive changes to the Act, as well as EPA rules that dictate certain subdivision master plans. To best serve your clients, stay informed about pending legislation and amendments that govern sales and marketing activities within your state and beyond the borders. Remember, it is possible to be caught in the middle if you aren't fully aware of the basic requirements and exemptions of the Act. Protecting your professional reputation and personal financial assets starts with educating yourself and your clients about local, state, and federal real estate laws.